Honorable Sri Justice Avadhanam Haranadha Sharma Garu. Representing the petitioner team is team code WA918 and representing the respondents team is team code VF721. Thank you. The Honorable Chief Justice and Associate Justices of High Court of Swatantra Pradesh. All persons having business before the Honorable High Court of Swatantra Pradesh are admonished to draw near and give their attention. The court is now sitting. Please be seated and maintain order. Before we commence, we would like to remind everyone that use of laptops, cell phones, or other electronic devices are strictly prohibited during the proceedings. Kindly ensure that all such devices are silenced and refrain from taking any photographs from your personal gadgets. Additionally, we would like to ask you to remain seated throughout the proceedings and not leave the courtroom. Following the conclusion of proceedings and announcement of awards in the valedictory session, we invite you for a short lunch. We look forward for seeing you there. Thank you very much. We hope you enjoy today's competition. Now we will read over some important guidelines for the team to ensure smooth and efficient conduct of proceedings. We request all the participants to maintain decorum and silence throughout the proceedings to preserve the integrity of the court. Participants are urged to refrain from disclosing any personal information during or after the competition to ensure privacy and confidentiality. Each team is allotted a strict time limit of 45 minutes for presentation of their memorials, including rebuttals. Each team may reserve up to 5 minutes for rebuttals or re-rebuttals as applicable. To assist in time management, a time notification will be prominently displayed occasionally during the proceedings. We request the researchers to remain vigilant regarding the timer. Upon conclusion of the allotted time, a distinct auditory signal will indicate the cessation of arguments unless an extension is granted by the Hon'ble bench. At the conclusion of the proceedings, the court will observe a brief recess for tabulation of marks and declaration of results by the tabulation committee. We request the Hon'ble bench to be pleased to bless us with their insights and wisdom of words of wisdom. The Honorable High Court of Swatantra Pradesh is now in session. Before this esteemed court, the matter of Reddy versus State of Swatantra Pradesh and others under that petition 46 of 2026 is scheduled for hearing today. We anticipate engaging arguments from both petitioner and respondent teams. With the permission of the Honorable bench, may the petitioner commence the argument.
Am I audible? Indeed, Your Lordship. The counsel appearing on behalf of the petitioner in the matter of Reddy versus Arogya Fertility Center and others under Article 226 of the Constitution of Andhra Pakistan, Your Lordships. Your Lordships, if the Honorable bench permits, the counsel seeks to brief the bench with the facts of the case. Much obliged, Your Lordships. Your Lordships, Dr. Aravind Reddy, a cardiologist, and his wife Anjali Reddy, a classical Carnatic vocalist, were... Indeed.
Little bit slow.
Okay.
Don't be too hurry. Yes.
Dr. Aravind Reddy, a cardiologist, and his wife Anjali Reddy, a classical Carnatic vocalist, were unable to conceive due to a medical condition affecting Anjali. In 2007, they opted for gestational surrogacy through Arogya Fertility Center, where Lakshmaiah acted as the surrogate. Unknown to the intended parents and to the surrogate, the clinic used sperm from an anonymous donor whose identity was kept confidential under a written anonymity agreement. On 12th January 2008, a girl named Arif Reddy was born and was legally recognized as the child of Dr. Aravind Reddy and Anjali Reddy. Arif grew up believing them to be her biological parents. However, during a school genetics project, she discovered inconsistencies in blood groups which raised questions about her genetic origins, Your Lordships. In 2024, Dr. Aravind Reddy was diagnosed with Telangana cardiomyopathy variant, that is TCV, a hereditary cardiac disorder. While reviewing family medical records in March 2025, Arif discovered references to donor number 32, after which her mother revealed that Arif had been conceived through donor-assisted reproduction. After attaining majority, Arif approached Arogya Fertility Center in January 2026, seeking disclosure of donor's identity or at least his genetic and medical history. The clinic refused. Your Lordships, with the Honorable Bench permission, the Council would like to submit compendium, Your Lordship. After attaining majority, Arif approached Arogya Fertility Center in January 2026, seeking disclosure of the donor's identity or at least his genetic and medical history. The clinic refused, citing confidentiality agreements, privacy concerns, and statutory policy regarding anonymity in assisted reproduction. Subsequently, an inquiry suggested that the donor might be Shrikant Bhagavatar, a prominent political figure who opposed disclosure on grounds of privacy and potential personal harm, Your Lordship. In March 2026, Arif developed cardiac symptoms and her cardiologist advised that paternal genetic history is necessary for proper diagnosis and risk assessment of TCV, that is Telangam cardiomyopathy variant, Your Lordship. Due to the clinic's refusal to disclose the information,
as per your submission, she approached even prior to the cardiac problem, the center for certain details. She approached even prior to that.
indeed, Your Lordship.
Do you have any reason for such approaching as the facts supplemented, as per the facts supplemented, facts supplied to you, or is there any basis for her approaching the
Indeed, Your
fertility
Lordship.
center for that details even prior to the cardiac problem? What is the basis? And what made her to approach the center for certain details even before the cardiac problem?
Even before the cardiac problem, as mentioned in the part 6 of the Moot Court proposition, Your Lordships. Part 6 of the Moot Court proposition.
Should we take it as out of curiosity, or should we take it as something? What is the basis? What is your inference?
Your Lordship, our inference here is that it is not out of mere curiosity the petitioner has approached this honorable court. It is on the very legal basis that Arif the petitioner wants to know her genetic origins, and as well as because of the pressing medical emergency.
Counsel, understand the question posed by the bench. It is not the question from the bench that her approaching the center first, not the court. Is it after coming to know about the disease she approached the center or prior to that? That's what the bench is asking.
If it is on cardiac problem, we can understand for detecting the medical reasons, etc., genetical related issues, we can understand. As per your submission, she approached even prior to the so-called cardiac problem.
Indeed, Your Lordship.
So whether should we infer that it is out of the curiosity or what made her to approach it? Okay, proceed further. Yes, sir, please proceed. Proceed further.
Due to the clinic's refusal to disclose the information, Arif filed a writ petition under Article 226 of the Constitution of Swatantra Pradesh, seeking recognition to the right to know one's genetic origins under Article 21 and disclosure of the donor's identity or at least his medical and genetic information, Your Lordships. If the Honorable Bench is satisfied with the framing of the presentation of the facts, the Council seeks permission to move on to the issues involved, Your Lordships. Your Lordships, there are three major issues involved in the present case. The first issue is that whether the right to know one's genetic origins forms part of the right to life and personal liberty under Article 21 of the Constitution of Andhra. The second issue is whether a donor's right to privacy may her right, a donor conceived adult's medically necessary claim to genetic information. The third issue before this honorable bench is whether contractual confidentiality in assisted reproduction can supersede constitutional protections of dignity, identity, and health, your lordships. If the honorable bench is satisfied with the framing of the issues, the council seeks permission to move on to the arguments involved. The council shall be dealing with the first and second issues, and my learned co-counsel shall be dealing with the third issue, respectively, your lordships. Much obliged, your lordships. Your lordships, at present, the first issue before this honorable bench is that whether the right to know one's genetic origins forms part of the right to life and personal liberty under Article 21. The counsel for the petitioner most humbly submits before this honorable court that right to know one's genetic origins forms an integral part of the right to life and personal liberty guaranteed under Article 21 of the Constitution of Andhra Pradesh. Much more importantly, your lordship, the right to know one's genetic origins is also a human right. Article 21 has been expansively interpreted by this honorable court to include not merely physical existence, but a life with dignity, identity, autonomy, and health, your lordships. In the present case, the petitioner Arif, who was conceived through donor-assisted reproduction, seeks access to the genetic and medical history of the donor, your lordships. Such information is indispensable for understanding her identity, health risks, and reproductive choices, your lordship. Denial of this information deprives her of the ability to make meaningful decisions about her life and therefore violates the guarantees of Article 21 of the Constitution, your lordship.
What is meaningful? What is meaningful according to you? She is saying that it's meaningful life. What does it mean?
Your lordships, in the present case, the petitioner Arif, she doesn't know what her genetic origins are. So because of that, she questions herself like, who am I or who I belong to, because of not knowing about genetic origins, or as mentioned in the Moot proposition about her Courtroom lineage, which is indirectly affecting her mental health also, your lordship.
Courtroom.
Indeed, your lordships, to make, if the petitioner, if in the future, to have a healthy life with full knowledge of her family, for that she needs to know her genetic origins, your lordships, which will definitely lead to a meaningful life. Because
At the cost of the other person's life.
it's not at the cost of other person's life, your lordship, because the petitioner has initially approached Arogya Fertility Center for disclosure of the genetic information, your lordship. That arose because the commissioning father and mother who were there, they also, in the Moot proposition itself,
How would you connect Article 21, protection of life and personal liberty, to the information about the parentage? Whether it falls within the scope of Article 21 to know the lineage, who is father, who is mother, whether will fall within Article 21, particularly when it is guaranteed against the state, the rights, fundamental rights. Now your relief is against the father. How do you bring a personal relief between the father and this a personal right is a right against the state? How do you link that to the jurisdiction of this constitutional court, that such information is falling within the scope of 21? Where is the state's intervention as to obstructing the thing, and where does the state come in the picture?
that I'll be dealing in the further issues, your lordships, if the honorable bench.
You may, if you have formulated such question, now probably the issues you raise is the page 8, 1, 2, 3 issues. Whether
The right to know what genetic origin form part of the right to life and personal liberty and not that's what the first issue is. Now we are arguing that issue.
Indeed, your lordships.
how would you get the information, right to information about the parent, who is parent, falling within Article 21?
Your lordships, we are not seeking the right to information of the biological parent, that is the donor. We are here before this honorable court to know about the genetic origins for the understanding of the petitioner here, your lordships. Because the petitioner has been in the dark, believing that now she is the biological daughter of Dr. Aravind Reddy and Anjali Reddy, your lordship. So as Article
Is it a
21
constitutional right? Is it a fundamental right? Is it a constitutional right? Is it a natural right? What is the branch under which it falls?
it is a human right, Your Lordship, and much more than that, we have come to this honorable court to
How do you justify that it is a constitutional and fundamental right?
human right, and because before we appeared before this honorable court.
So human right also falls under Article 21 according to you. Every human right falls.
Not every human right, Your Lordship, as right to health was already recognized in Article 21. As
Proceed.
Your Lordships, continuing my arguments, the one thing which I want to say is that as Article 21 is expansive and it has included the right to privacy, right to health and dignity, we have approached this honorable court that to recognize genetic origins is also a facet of Article 21, Your Lordships.
No? Maybe. So, my brother is here. So dignity, knowing now Arvind Reddy is your father according to all your record. Now, knowing somebody or detecting somebody being the father, will it protect the dignity or affect the dignity?
Answering your
Practically
question,
speaking and theoretically and technically speaking, where would the court may have to ultimately stand or you will be standing?
answering your question, Lordship, here the petitioner has approached this honorable court only to know about her genetic origins and the genetic information, Your Lordships. In the facts itself, it is nowhere disclosed.
That according to you falls within Article 21. You
Indeed,
stand
Your
by that.
Indeed, Your Lordship.
Okay, fine. Fine. Next.
Moving on to the arguments of my first issue, Your Lordships. The petitioner RF, who was conceived through donor-assisted reproduction, seeks access to the genetic and medical history of the donor. So further, Your Lordship, on this account, the council would like to make a submission to the honorable bench. Your Lordship, the submission is based on the Indian Journal of Law and Legal Research, where the psychological importance of genetic identity in the research was specifically mentioned. The empirical data, which states that around 94% were born without knowledge of their donors, especially in the donor-conceived assisted reproduction, as the matter before is in the before court. And almost 85% described a shift in the sense of self following discovery of the conditions of their conception. Half had access psychological counseling to deal with their emotions, Your Lordship. This data demonstrates that significant psychological consequences that may ensue from disclosure of one's donor conception status, particularly where access to information about genetic origins is being limited, Your Lordships. Your Lordships, the council also humbly submits that without knowing the genetic origins, the personal self-understanding of the petitioner in the present case is not known. She is kept in the dark that her gotram, she doesn't specifically know about her gotram, and she also doesn't know about her lineage, what her genetic lineage is that. And to further argue, Your Lordships, it is also that...
Is it your case that, is it your case anyway that unless you know the parent who is now the proposed respondent is your the donor of the sperm, something like that, you can't have the proper treatment. You can't have proper, is it a psychological factor? Is it a curiosity factor? Is it a medical factor? Where do you exactly stand?
Your Lordship, according to the first issue as given in the Moot proposition, it is upon the psychological factor.
Every time we need not say that Moot proposition.
Indeed,
It's a
Your
fact
Lordship.
admitted.
Indeed,
It's a
Your
fact
Lordship.
admitted
Indeed.
as per the facts asserted and is a fact asserted.
Indeed.
So where is it said that it is absolute necessity, medical necessity to know without such information you cannot be treated for particular such and such an ailment. Is it there in the facts asserted by you for the relief prayed for?
Indeed, Your Lordships.
Can you invite our attention to a particular line or para where as per the facts asserted in the fact pattern
Indeed, Your
that,
Lordship.
that medical necessity was there, acute medical necessity was there to know about the parentage.
Part 9 of the Moot proposition,
Part 9.
where the third line, where it is clearly stated that definitive diagnosis of suspected TCV requires paternal genetic history.
Let me please. Definite diagnosis of suspected TCV requires parental genetic history. Options of such information relate to risk of assessment, care, and counseling regarding the future offspring. So your start point is medical necessity. Your start point fund basic this main attack point is medical necessity.
Indeed, your lordships. Genetic origins and medical necessity.
Genetic origin will be helpful for treatment.
Therefore, the assisted regulate referred to technology regulation act 2021. There is one out of result of part from the diagnostic of the commission of.
I did not get your question, your lordship. Could you please repeat it?
However, assisted reproductive to technology regulation act 2021.
Indeed.
That you have submitted just now. You have submitted that some paper now, some article. A child born as a result of part shall be the biological child of commissioning couple and shall therefore enjoy the rights and privileges of natural child of the said couple.
Your lordships, this confidentiality agreement or when the donor was born, the particular legislative like the Assistive Technology Act was not in force, your lordship. So that cannot be applied retrospectively in the present case.
So
Then in the absence of that, in the absence of that, your lordships, they entered into a confidentiality agreement. But here in the present issue, we have only come before this honorable court to know that because of the pressing medical emergency, that diagnosis of the definitive diagnosis of TCV, the paternal genetic history is required, your lordships, and also for the genetic origins to be known for the petitioner, your lordship.
in one way, you say that this act and the provisions are ex post facto, you can't apply, you can't invoke them. Even right also, section 8 recognized under this act also, you can't, even that right is also very limited. Even that is not available to you. So you go by the general
Indeed, your lordships, because
human
the
right and general right only.
Indeed, your lordships, because while RF was born, the petitioner, before even the donor or the FC fertility clinic center, when they entered into the agreement, the law was very rigid, especially in aspect of the rights of the child, your lordships. And even if we per se hypothetically think that if we apply the Assisted Reproductive Technology Act hypothetically to the present issue, in the act itself, the act itself is also clearly silent about the rights of the child, your lordship, because the genetic. If we even suppose, even if we think that hypothetically, that they are the commissioning parents have every right over the child and all, but how is the hereditary, like the genetic information will be known to the petitioner? Because the AFC clinic is clearly stating that the information will not be disclosed. Because of the lack of information, the diagnosis cannot be done in the present case, your lordship.
Genetic information of both the parents or one parent?
Only the donor, your lordship. Only the donor.
Why not the other person then? It's parents. You want the information of the genetic information of the parents, or only one parent? If you are then, are you not discriminating the parents?
No, not at all, your lordships. To answer the question which was posed by the honorable bench, it might seem that it is going out of facts, but I would like to make my argument as well that Anjali Reddy in the part in part 6 of the Moot proposition, it is clearly stated that when the petitioner confronted her mother about knowing the complete truth, the disclosure revealed that ovum was Anjali's, but this sperm has originated from an anonymous donor. On the presumption, we can, because the Moot proposition's facts are silent, your lordship. So from this, we can infer that the petitioner might already have the genetic information of the mother, your lordship. But there is an absence of the paternal genetic history, which is extremely required in the present case, your lordship. With the honorable bench permission,
Yes, please.
indeed, your lordship. Your Lordships, the Council draws the Honorable Bench attention to the page 15 of Memorial and flag number 8 of the Compendium, Your Lordship, of the petition. The Council further humbly submits that the courts have also acknowledged the significance of knowing one's biological roots, Your Lordships. In Fabian Ricklin versus State of West Bengal, the Honorable Calcutta High Court observed that the right to know one's roots is implicit in human existence and forms part of an individual quest for identity, Your Lordships. Your Lordships, furthermore, the right to know one's genetic origins is closely linked to personal autonomy and decisional privacy, Your Lordships. In Justice Case Puttaswamy versus Union of India, 2017, the Honorable Supreme Court held that right to privacy is a fundamental right under Article 21 and includes decisional autonomy relating to intimate personal choices such as reproduction and family life, Your Lordships. Similarly, to further buttress my argument, in Suchita Srivastava versus Chandigarh administration, the court recognized that a woman's right to make reproductive choices, such as in Suchita Srivastava versus Chandigarh administration, the court recognized that a woman's right to make reproductive choices as a dimension of personal liberty under Article 21, Your Lordships. Applying this to in the present case, our wife cannot meaningfully exercise her reproductive autonomy without access to the donor's genetic and medical history. Without such information, she is not able to assess the diagnosis which was stated by the medical professional or the doctor for the definitive diagnosis of TCV, Your Lordships. And without such information, she cannot assess the possibility of transmitting hereditary conditions such as TCV, which was mentioned in the proposition to her future children, Your Lordships. Consequently, denial of this information renders her reproductive choice illusory and directly infringes her decisional autonomy and privacy under Article 21, Your Lordships. Your Lordships, the Council draws the Honorable Bench attention to the flag number 1 of the Compendium, Your Lordships. The right to life under
Page number?
flag number 1 of the Compendium, Your Lordship.
Can you see the page number or flag?
I suppose you don't have the Compendium.
It's a compendium with me.
That is the Memorial, Your Lordship.
No, do you have the compendium? No, compendium. Bottom page. No, there's a compendium.
Indeed, Your Lordship, there is a Compendium as well.
Separate compendium is there? So, it's a separate one or the same one?
There is a separate Compendium, Your Lordship.
Compendium. Oh, what's only one page. Okay,
There
no
is
problem.
only one Compendium.
No problem.
Sorry
Yes,
for
yes,
that,
yes,
Your
yes,
Lordship.
yes.
In the flag number 1 of the Compendium, it is clearly the case which I want to cite is that in Pashchupenga Khet Mazdoor Samiti versus State of West Bengal, the Honorable Supreme Court held that preservation of human life is of paramount importance and the state has a constitutional obligation to ensure access to medical care. In the present case, RS cardiologist has clearly stated that a definitive diagnosis and risk assessment for Telangana cardiomyopathy variant requires knowledge of paternal genetic history. Without such information, preventive care, accurate diagnosis, and genetic counseling becomes impossible, Your Lordship. Your Lordship, by permitting the clinic to withhold such vital, necessary genetic information of the donor, the state effectively obstructs RF's ability to protect her own life and health, as well as the state of her potential children, thereby violating Article 21, Your Lordship. Your Lordships, beyond medical necessity as well, it is most humbly submitted before this honorable bench that the denial of genetic origins constitutes a direct infringement of the petitioner's right to freedom of conscience and practice under Article 20.
Freedom of?
Freedom of conscience, Your Lordship,
Okay.
conscience.
Oh.
And religious practice under Article 25.
Religious practice also.
Indeed, Your Lordships.
How could it be?
In the Moot court proposition, it was clearly stated about the Courtroom, Telangam culture and the lineage as well, where they have clearly emphasized about how the lineage. I would like to direct the court's attention to the Moot court proposition.
I think 4 or 5. Oh.
In the first page of the Moot court proposition, Your Lordships, part 1, It clearly states that notably certain musical compositions, particularly the rare Sarasa Kritis, are believed within particular lineages to try aesthetic nonsense inseparable from familial inheritance, your lordships. In the present case, your lordships, how it is directly affecting the petitioner is that the petitioner is aware of the mother's, the maternal side of the genetic history and the genetic origins here. And she also completely knows about how her religion is practiced, how her, like her biological, the mother is, just a moment, your lordship, just a moment.
Please, please, please.
In the present case, the petitioner is well aware about her mother's genetic origins and lineage and what are the traditions she practiced. In the part 2 of the Moot proposition as well, your lordships, in the Moot proposition itself, it is clearly stated that
You complete this particular point. I have something to ask. If
Yes,
you
please.
completed it.
Complete, then we'll pass.
Now you are submitting a point. To complete that point, I have a further query on that. Relating to that.
indeed.
Break time. Your point and you completing your particular point, now you are addressing the next point from this bench.
Yes, counsel, please proceed.
The Honorable Supreme Court in Francis Corel Mullen versus Union of India held that right to life includes the right to live with human dignity.
Which page of the compendium? You're citing some citation?
Indeed, your lordship,
Citation.
that is not flagged in the compendium.
What citation? No, I don't.
Page number 13 of the memorial, your lordship.
32.
Sorry for the inconvenience, it is not mentioned in the compendium.
Page number?
13 of the memorial, your lordship. Petitioner's memorial.
Yes. Just give citation. What
Could you
citation?
please skip this? Francis Corel Mullen, your lordship. With the honorable bench permission, may I continue with my arguments? Held that right to life includes the right to live with human dignity. In the petitioner's case, her genetic lineage shapes her gotram, ritual belonging, and marital legitimacy, your lordships. The inability to ascertain her paternal lineage renders her gotram indeterminate, creating a vacuum in her cultural identity, your lordship. This cultural dislocation is not trivial. It is a direct impairment of her dignity and her right to freely practice the essential traditions of her community. The Honorable Court, the counsel before the Honorable Court pleases that the petitioner is not prevented from defining her own identity and maintaining her spiritual connection to her lineage, your lordships.
A counsel, is it a ratio or arbiter?
It is a ratio, your lordship.
Huh?
It is a ratio, your lordship.
Ratio, not arbiter.
Not in.
What are the facts of the case?
Can I take a moment for that, your lordship?
Yes. Definitely. Good one. Francis. True. Yes, concept.
The council is not well aware with the facts of the
No
case
problem.
in certain.
Yes, please proceed. Yes, please. Yes, no problem. Yes, please.
Applying these principles to the present case, if the petitioner is denied access to information regarding her genetic origins, she would suffer grave consequences that extend beyond mere curiosity, your lordships. The absence of such information deprives the petitioner of the ability to fully understand herself and her biological identity, heritage, which all forms an essential aspect of personal identity and dignity, your lordships. Furthermore, the lack of knowledge regarding her reproductive choices, including assessing the risk of transmitting hereditary diseases, such as the TCV in the present case, consequently, the continued denial of access to her genetic origins not only causes profound psychological stress to the petitioner, but also undermines her autonomy, health, and reproductive decision making, thereby affecting the court protections guaranteed under Article 21 of the Constitution, making the petition squarely maintainable before this honorable court, your lordship.
Yes, counsel.
Whether the contract of confidentiality between that the center which has undertaking the exercise of this surrogacy issue, that they should not reveal the information, was prohibited by them as per any law. Whether it was illegal, whether it was prohibited, whether it falls under any of the prohibited categories under Contract Act.
I think that that's the question. There are other writings. Other counsel will argue that. No, they were
No,
arguing
no,
that.
they,
Not-
you have co-counsel to argue that, you will be completing entire argument.
She is saying
You are the
that
total
it's one and
presenter
two
or some other?
1 in
presenter?
2, your lordship.
One and two. She is talking one and two only. The other person will
1
argue
in 2.
that.
The confidentiality agreement will be
We
dealt
will
with.
reserve that for your other parties.
Yes, yes.
Indeed, your lordship.
Yes, he'll argue that. Yes.
If the honorable bench is satisfied with the issue 1, the council seeks permission to move on to the issue 2 of the present case, your lordship.
Yes, please.
In the present, the issue 2 before this honorable bench is that whether a donor's right to privacy may override a donor conceived adult's medically necessary claim to genetic information. Your lordships, the counsel for the petitioner most humbly submits before this honorable court that a donor's right to privacy cannot override a donor conceived adult's medically necessary claim to genetic information, particularly when such information is essential for the protection of life, health, and reproductive autonomy under Article 21 of the Constitution of Andhra Pakistan, your lordships. The petitioner, Arif, seeks access to the donor's genetic and medical history not out of curiosity, but out of a compelling medical necessity, your lordship. Her request arises from constitutional guarantee of life, dignity, and health under Article 21, read with Andhra Pakistan's international obligations under Article 12 of the International Covenant on Economic, Social, and Cultural Rights, your lordships, which I'll be dealing with in my issue. At the outset, your lordships, the council further humbly submits that the right to life under Article 21 includes the right to health and access to medical information necessary to protect life, your lordships. Constitutional jurisprudence has repeatedly
It's expansive definition. You are expanding that Article 21. Okay.
Constitutional jurisprudence has repeatedly recognized that life under Article 21 means a life with dignity, bodily integrity, and the ability to make autonomous decisions concerning one's health, your lordship. In the present case, Arif has begun experiencing cardiac symptoms, and her cardiologist clearly stated that for the definitive diagnosis of TCV, variant requires paternal genetic history, your lordship. Without access to such crucial genetic information, Arif cannot obtain accurate diagnosis, preventive treatment, or genetic counseling. The continued concealment of the donor's genetic information under the cloak of anonymity therefore obstructs her ability to safeguard her health and infringes her fundamental right to life, your
Okay,
lordship.
we understand. If at all it is a medical reason, you stand that you want to protection of life, therefore it's a medical reason, you are entitled to relief under Article 21, fine. Now the foundational factor for to have the information, there must be some basis and foundational fact in your case. Except the medical problem of Arvind Reddy, who has suffered a cardiac problem, that made you to suspect that you also may get, that's all.
Indeed,
It is only your apprehension or supposition at that stage that you are also likely to go. My father got, natural, if presumed or natural father has got. Therefore, I am likely to get is only an apprehension. It is not based on any sound material at this stage. How are you entitled to have the relief just mere on suspicion without any? The foundational fact is the sickness of Arvind Reddy, not your. Nothing made you to suspect that you are sick. Part 9 or part 9? You may check it. Part 9. You say? Definitely. Father, are you experiencing symptoms? No.
Your Lordships.
Physical discomfort and shortness of.
This
Your
is the
Lordships.
basis for you to, for all this entire exercise.
Indeed, Your Lordships, the Council to further buttress my contention, and the Council would like to also make a submission regarding this, Your Lordship, that we have not approached this Honorable Court on mere suspicion or allegation or out of curiosity. We have the scientific evidence, Your Lordship. Your Lordships, the present submission which is before the Honorable Bench is that it is the blood chart where it clearly states about the paternal blood type and maternal blood type in the present case. Here, in the Moot Court proposition, they clearly stated that Arvind Reddy and Anjali Reddy, they both have the O positive or O blood group, Your Lordships. But here, Arif has the B positive blood group, Your Lordships. Based on when the petitioner has approached the Arogya Fertility Center, they gave a very limited disclosure stating that donor number 32, blood group B plus, Telangam Brahmin lineage, engagement in party work, no family history of cardiac disease, Your Lordships. Your Lordships, here, the petitioner has approached the Arogya Fertility Center before approaching this Honorable Court on the very need that the Arogya Fertility Center will reveal the genetic information which is necessary for diagnosis of PCV, Your Lordships. But applying this to the present case, here, Arif's B positive blood group and the donor which they are citing here, the Arogya Fertility Center, B positive blood group is also same, Your Lordship. And the engagement in party work and it is similar to the, when applied together, it is similar to the Srikant Bhagavata that is respondent to, Your Lordship. Your Lordship, to further state that we have not, the petitioners have not come to the court on the mere assumption or speculation that respondent to might be the potential donor, the Council would like to draw the kind attention of the Honorable Bench to the Moot proposition. There, in the confidentiality agreement, part 3 of the Moot proposition, Your Lordship, where second paragraph, part 3 of the Moot proposition, Your Lordship, it is clearly stated that unknown to the intended parents and to Lakshmi, the sperm used in the procedure originated from an anonymous donor sample archived by AFC in 2006, Your Lordship. Your Lordship, the petitioner Arif here in the present case was born on 12th January 2008, Your Lordship. And further, Your Lordship, and as the information given by the AFC in part 4 of the Moot proposition, they gave that the age is 32, and in part 7 of the Moot proposition as well, when the petitioner has approached the Arogya Fertility Center on 12th January 2026, they gave a minimal, very limited disclosure without any stating any genetic, they did not reveal any genetic information, stating that potential harm to the donor now described as a political figure, Your Lordships. Based on this inference, the very facts which are given in the present Moot proposition itself, the petitioner was compelled, he was made to infer indirectly before approaching the Honorable Court, Your Lordship, because there was no evidence, proper evidence to show before this court. And in part 8 of the Moot proposition as well, Your Lordship, if the in the part 8 of the Moot proposition as well, it is clearly stated that we assume the Honorable Bench's question was that we are assuming that on the mere assumption that to know the paternal genetic history, but when it is linked with the respondents to information here, Here, the donor was eventually inferred to be Shrikant Bhagavatar, a potential CM. The Department of Happiness of the state. He is an anticipated chief ministerial candidate and a vocal critic of art, your lordship. Upon receiving a copy of legal notice, he instructed his counsel to oppose disclosure on grounds of absolute contractual confidentiality, right to privacy and family life, and irreparable personal and political harm, your lordships. When combinedly,
15 minutes time is remaining for both, I believe, not for both in the sense one side participant, for petitioner side.
For the speaker only.
For this individual? But point number 1 and 2 are, you said that 15 minutes time is remaining for this group, us as a whole. So,
so your lordship,
briefly, you have elaborated every fact, find, that's okay.
now they are-
Lastly, only one point, either you or your counterpart who is going to submit may cover, then what is the role of the state or what is the applicability of the writ jurisdiction in respect of disclosure of information which is purely contractual and private between the parties. That you may address within 1 or 2 minutes, or your next participant from your end may submit that. The invocation of jurisdiction of the High Court under 226 and the direction for disclosure of an information which is purely contractual, which was not prohibited. That jurisdiction is there or not?
disclosure of the genetic
Not the state role was not there. State role was not there. State role was not there. They are Indian against the state.
Whenever you're approaching a constitutional court, you have to establish the breach, infringement and the corresponding legal obligation.
And why didn't you not approach the other remedy available before the other court? Whether this is the only remedy available to you, or you have any other remedy under the other laws and other courts?
Alternative
Then alternative remedy. In the absence of approaching or exercising or opting for alternative remedy, how are you competent to approach this court?
Your lordships, as Article 226 of the Constitution of Andhra Pradesh has wide powers, where it also deals with fundamental rights as well as legal rights, your lordships. And we approach this honorable court because the first thing is to know the genetic origins and to seek before this honorable court that it is an integral facet of Article 21. And the second issue is also because of the petitioner's medical necessity or the urgency of the petitioner for the diagnosis treatment of the TCV, your lordships, because we believe that prevention is better than cure. So on that basis, we have approached this honorable court to seek this relief, your lordship.
You plan yourself. If your group is having 15 minutes time in what set?
Indeed, your lordship. I'll just go on with the arguments in brief. Your lordship, it was also clearly stated in United India Insurance Corporated Limited versus Jayaprakash Tayal, flag number 2 of the compendium, where discrimination based on individuals' genetic lineage, genetic heritage is impermissible. Therefore, the denial of medically relevant genetic information amounts to arbitrary and unjust discrimination in the present case, which violates Article 14, your lordship. And further, it also violates Article 19(1)(a), your lordships, that is, knowledge of one's biological origin is closely connected to the exercise of freedom of expression and personal autonomy under Article 19(1)(a). The Honorable Supreme Court in Jigya Yadav versus CBSE recognized identity as a constitutionally protected interest and described it as an amalgamation of various internal and external characteristics that define an individual. For a donor-conceived adult, genetic origins forms a foundational aspect of identity and self-understanding of the petitioner, your lordships, in the present case. When the state regulates,
You are be missing the second point, and your other presenter will not have the sufficient time. So you decide the time taken by you. Whether you have
God issue is there now. God issue has to be covered by your other
45
partner.
minutes, only 15 minutes. Has been
Indeed, your
remaining.
lordships.
It is cautioned about the 5 minutes, 3 or 4 minutes.
indeed, your lordship, summing up my
Point is to be addressed and other.
It's the time.
Summing up my arguments, your lordships, it is in the issue 2, Articles 14, 19(1)(a) and 21 of the petitioner also being violated, your lordships. If the honorable
Issue
bench is
2,
satisfied,
Article 14, 19, 1A also.
indeed, your lordship,
Hmm.
and 21 because of the health, your lordship, in the present case. If the honorable bench is satisfied with the issue 2, the council, my learned co-counsel shall be dealing with the issue 3.
Summing up is what about issue number 1? You summed up, you are supposed to say even issue number 1 also. You are summing up now, na? Issue 3 is said 14, 19, 1A and 21. What about issue number 1 then? Because that's also same one line answer. How do you sum up issue number 1?
To know about the genetic origins, Your Lordship. To be to be also recognized in the Article 21.
That's also Article 21.
It is an integral facet of Article 21, Your Lordships.
Yes.
Much obliged, Your Lordships. My learned co-counsel shall be dealing with the issue from here.
Yes, please.
Much obliged, Your Lordships. The counsel appearing on behalf of the third issue before the Honorable Court, Your Lordships. The third issue before the Honorable Court is whether the contractual confidentiality in assisted reproduction can supersede the constitutional protections of dignity, identity, and health, Your Lordships. Your Lordships, behind this legal question lies a deeper constitutional injury, Your Lordships, where enforced anonymity has deprived the petitioner identity, dignity, and even access to health care, Your Lordships. The counsel humbly submits that contractual confidentiality cannot override the constitutionally guaranteed fundamental rights of dignity, identity, and health, Your Lordships. My Lordships, the Constitution stands supreme over any private agreement, and any contract inconsistent with fundamental rights is unenforceable, Your Lordships. With the Honorable Court's permission, the counsel would like to argue this issue in twofold argument, Your Lordships. Much obliged, Your Lordships. Firstly, right to dignity, identity, and health are the constitutionally guaranteed fundamental rights, Your Lordships. And secondly, any contractual agreement inconsistent with cannot supersede the constitutional protections, Your Lordships. In first limb of my argument, the counsel would be arguing that right to dignity, identity, and health are the constitutionally guaranteed fundamental rights, Your Lordships. My Lordships, firstly regarding identity, Your Lordships, the problem explicitly states that Telanganam cultural traditions attach significance to lineage and gotram, Your Lordships. These determine ritual identity, marital eligibility, cultural belonging, inheritance to artistic traditions, Your Lordships. Since Arif does not know her paternal and genetic history, her gotram remains uncertain, her cultural belonging become incomplete, her place in musical lineage is questioned, Your Lordships. This creates identity vacuum which directly affects the human dignity. Your Lordships, human dignity under Article 21 of the Constitution includes psychological and mental integrity, Your Lordship. The Honorable Supreme Court of India and Francis Court.
Is it not contradictory that one way health issue, one way the psychological issue?
Yes, Your Lordship.
They both runs contradictory?
No, Your Lordship. Both are
There is
simultaneous.
a psychological problem after coming to know in the year 2025, 2024, Arvind Reddy problem. 2025, incidentally, your mother disclosed when some issue is there. 2026, you gone for checking it. 3 consecutive, if you see the succession of facts, succession of events, 24 is the original thing, 25 somewhere mother discloses, and 26 you got for checking. So whether your psychological stress, self-made stress made all these things to suffer plus feel like uneasiness and other thing, or it is only a medical reason, one thing.
My Lordships, in part 10 of the Moot proposition, it was clearly held that the counsel for petitioners only are asking for the disclosure of identity, alternative to the identity, disclosure of medical and genetic history, which provides preventive treatment to the Telanganam cardiomyopathy variant, Your Lordship.
So let us take for a while that as far as the first point you formulated that medical necessity is there, therefore you are entitled, therefore the dignity issue is there, you are entitled. Next, let us come to the second part, which is more crucial. In the absence of any prohibition for a contractor to have the confidentiality, to have the agreement not to disclose with the, now the 2 things are there. One, contractual obligation, contractual protection, not is an obligation, a contractual protection to the donor of the sperm that his identity will not be disclosed. Equally, it affects the privacy, equally it affects his dignity also. The comparative dignity between the petitioner and the comparative dignity of the donor, and the confidentiality, which is not prohibited, which is supported by the contract. That is one side that is to be looked into. So that is not prohibited. Which is not prohibited, can it be said as unconstitutional, and constitutional protection is not there for that?
My Lordships, the contractual confidentiality affecting right to health, identity, and dignity, Your Lordships. Constitutional.
Not existing. That was not existing by them. That was not existing by them. It's purely futuristic.
Yes, Your Lord. Drawing court attention to the section 23 of the Indian Contract Act, which clearly stipulates that any contractual agreement opposed to public policy, Your Lordship. Yes, Your Lordship.
Precisely.
Here, the right to health is right to health of the child is comes under the ambit of Public policy, your lordships.
Now let us be very clear as to public policy. Public policy is what is prohibited by law, which is not prohibited by law, which is permissible by law, cannot be considered as opposite to public policy.
My lordship, a contractual confidentiality provision citing that no disclosure of donor's identity, which is helpful for the petitioner's health, your lordships, should be disclosed, your lordships. Every child who conceived through donor this assisted reproduction can have the genetic disclosure for his protection of right to health, your lordship.
So change in circumstance will change the terms, you mean to say? How is it a change of circumstance? It's a completely new circumstance.
Yes.
As far as the health reason
Yes,
is
your
concerned,
lordship.
it was not in anticipation by anybody.
So the petitioners pray before this honorable court is prioritize the constitutional protections over this contractual confidentiality which was happened in 2007, your lordships.
Okay.
Much obliged, your lordships. Continuing my argument, your lordships, in Francis Coroli Mullin versus Administrator Union Territory of Delhi, if the court permits 1 minute, the council will brief with the facts of Francis Coroli Mullin, your lordships. Much obliged, your lordships. In this case, a mother is a foreigner, your lordships. She was acquitted she was accused in a drug case, your lordship. She was in a police custody, and she could not meet her family, her child. So, your lordships, the court recognizing that in the submission, it's there, your lordships. Right to life includes right to live with human dignity, and all that goes with the namely the bare necessaries of life, such as adequate nutrition, clothing, and shelter, and facilities for reading, writing, and expressing oneself in various forms, your lordships.
No quarrel on that point. How
Yes,
you
your lordship.
fit in with that expressions is the point.
So, your lordship, the right to life includes with human dignity and well-being, your lordship. My lordship, the petitioner suffers with the existential uncertainty about her parentage, confusion regarding her lineage, fear of hereditary disease, and the social discomfort regarding her identity, your lordship. This results in a constitutional injury of dignity by creating identity vacuum and psychological distress, your lordship. My lordships, if court permits, secondly, I will go to the submission of regarding right to identity, your lordship. Much obliged, your lordship. Your lordship, the council most respectfully submits that identity is a core component of Article 21 of the Constitution of Andhra Pradesh, your lordships. My lordships, a person identity includes biological knowledge of biological parentage, genetic lineage, hereditary medical history, and social and cultural belongings, your lordship. The Honorable Supreme Court of India, in case Justice K.S. Puttaswamy versus Union of India, 2010, 10 SCC 1, while referring to the case of Dalsa versus Union of India, kindly refer to the flag number 10 of the compendium, your lordships. While referring to the Nalsa versus Union of India, recognizes that self-determination of gender is an integral component of personal autonomy and self-expression, and falls within the realm of personal liberty guaranteed under Article 21 of the Constitution, your lordships. So, Article 21 protects personal identity, personal autonomy, and informational self-determination, your lordships. Here, Ari was raised believing Dr. Arvind Reddy was his father, was her father, your lordships. She later discovered that anonymous donor was used, and the clinic refuses the information about the donor, your lordships. My lordships, this leaves the petitioner unable to determine her genetic identity, which directly interferes with the personal, with her constitutional right to dignity, your lordships.
How do you address the larger identity issues and dignity? Those two dignities are to be kept under your dignity issue as a subservient to your dignity. Conflicting dignities are there.
My lordships,
Which dignity is to be preserved when conflicting dignities are there?
my lordships,
It is something like a paradox. If it is disclosed, their dignity will be addressed. If it is not disclosed, your dignity, you are saying, which is
Which is the important quote.
my lordships, in case Puttaswamy versus
that is only Puttaswamy what deals with is the right to dignity is
In-
not conferred, right to privacy is conferred, recognized, right to dignity is are all recognized in the Puttaswamy.
No, Your Lordship. In case Puttaswamy, there was held that proportionality test, Your Lordship. Here, two fundamental rights. Yes, Your Lordship. Here, the proportionality, the court laid down four points, Your Lordship. That is state legal aim, necessity, rational connection, balancing of interest, Your Lordship. Here, the state legitimate aim is to protect the petitioner's health, Your Lordship. The necessity is genetic disclosure enables diagnosis of Telanganam cardiomyopathy variant, Your Lordship. Rational connection is petitioner health is connected with the confidentiality, Your Lordship. Balancing of interest, limited genetic data enables diagnosis without violating privacy, Your Lordship.
But how do you consider the proportionality between these two now? Goes by the benefit, no?
Yes, Your Lordship. Here, the legitimate aim is to protect the petitioner's health, Your Lordship. So, right to health override right to privacy, Your Lordship.
So narrowing down, now you are giving up the dignity issue. You are only on health issue. Ultimately, only on health issue you have to stand. Dignity issue has to be ignored in view of the conflicting dignity of the others. And privacy issue also is a secondary. Only medical issue you want to
In part 9,
embark upon.
Yes, Your Lordship. In part 9 of the Moot proposition, we have already mentioned that disclosure of identity. Alternatively, if disclosure does not permitted, the genetic data and medical data via neutral mechanism, Your Lordship. The submission is very clear that if the court does not reveal his identity, we need at least the genetic and paternal genetic data, which would enable the preventive treatment, Your Lordship.
Without disclosing the father's name.
Without disclosing the father's name, Your Lordship. Only the genetic data is useful for the petitioners, Your
So
Lordship.
now the relief would be against the first respondent alone, the institution that
On the-
which
on the-
first respondent to clinic which has entertained all this exercise.
Yes, Your Lordship.
Or is it against all?
On the request to the Arogya Fertility Center, they rejected the claim, Your Lordship. So,
So you want relief against the Arogya Fertility Center. Again, your team, I'm repeatedly asking, how would they be brought within 226?
my Lordship,
Where is the answer for bringing them within 226 per view? State, where is the state role? Where is the state can pressurize you or make you are not an agency and instrumentality of the state. Are you within Article 12? Whether Arogya comes, that so-called unit comes under the Article 12 expression? If you don't come under 12 expression, will you come under the part 3 relief under 226?
the bare provision of the Article 226 clearly states that
Even against the private individual, even against the private.
even against the individual, even against the authority, Your Lordships. In the Honorable, my
To
Lordship,
drive at that point.
my Lordship,
Do you- what is the authority you have that 226 can be invoked against even a private individual, private institution or private individual? Are you supported by any authority?
Yes, Your Lordships, the Honorable Supreme Court in recently 2023 in Kausal Kishore versus Union State of Uttar Pradesh clearly held that fundamental rights cannot be can be invoked against the individual or authorities, Your Lordships.
Thin distinction. That's where the thin distinction is asking. Please, again, frame that distinction. Thin distinction is there. What thin distinction? Because see, against you are asking an individual, now you want to enforce against an agency. Agency. Why you are? How do you make the agency liable for this?
Yes, Your Lordship, the agency is disclosing
Whether
the
agency comes under Article 12.
Yes, Your Lordship, this is an authority. Article 226 clearly stated that Article 226 can be filed against authority or another individual also, Your Lordship. Here the authority is disclosing public function, Your Lordship, regarding health, Your Lordship. That's fine.
Okay, you may now you may conclude 2 minutes subject to.
Yes, Your Lordship.
What you wanted to say is,
Public function.
so far as fundamental rights are concerned, the 226 can be maintained even against individual.
Individual.
Take an example, writ of habeas corpus. If an individual kidnaps or abducts a man, he can maintain a writ of habeas corpus under Article 226.
Yes, Your Lordship.
Not only state, even against individual also, for enforcing these rights,
Yes, Your Lordship.
it can be maintained even against private person.
Much obliged, Your Lordship. At this juncture, the council humbly submitting to guidance from the comparative jurisprudence, Your Lordship, which offers valuable insight to the similar constitutional questions, Your Lordship. In United Kingdom, the primary legislation, Human Fertilization and Embryology Act 1990, the shift away from kindly refer to Act number 21, Your Lordship. The shift away from the donor anonymity was implemented through Human Fertilization Embryology Authority Regulations 2004. These regulations allowed individuals conceived via donor gametes to access identifying information about their donor once they reach the age of 18, Your Lordship. In Germany, the right to know origins is a constitutional principle solidified by the Sperm Donor Act 2018. This legislation enabled a central registry to ensure children conceived through sperm donation can exercise their right to learn the identity of the donor, Your Lordships. In Victoria, Australia, Your Lordships, kindly refer to the flag number 22, Your Lordships. The relevant legislation is assisted reproductive treatment. This enactment landmarked by 2016 amendment, which retrospectively allowed all donor conceived people to have access regarding the donors, Your Lordships. To conclude this argument, Your Lordships, this case is not merely a contract dispute, it is the constitutional question. Therefore, this is a settled principle in the Constitution that Constitution is supreme over all private agreements and no contractual clause can be enforced if it defeats fundamental rights and public policy, Your Lordships. My Lordships, if the court is well satisfied with the issues, argument of the issue, the Council would like to move on to the prayer, Your Lordships. Therefore, in the light of facts stated, issues raised, arguments advanced, and binding precedents cited, the Council for Petitioners most respectably praise this Honorable Court to declare and judge that, my Lordship, kindly grant 30 seconds of time, Your Lordships. The right to know one's genetic origin is a fundamental facet of Article 21, Your Lordships, and issue writ of mandamus to the respondents to disclose the donors' medical genetic data and medical lineage data, prioritizing petitioners' right to survival and identity over confidentiality, Your Lordships, and or pass any such order that this Honorable Court may deem fit in light of justice, equity, and good conscience, Your Lordships. For this act of kindness, the Council for Petitioners forever duty bound to pay, Your Lordship. The Council rests the case, Your Lordships. Much obliged, Your Lordships.
With the permission of the Honorable Bench, may the respondent commence their arguments.
Please.
If it may please, the Council seeks permission to address the bench collectively as Your Lordship. Much obliged, Your Lordship. The Council appears before this Honorable High Court of Swatantra Pradesh in the matter of R.F. Reddy versus State of Swatantra Pradesh and others on behalf of the respondents arising out of a writ petition filed under Article 226 of Constitution of Andhra Pradesh. The facts have already been cited by my learned opponent counsel, but with the permission of Your Lordship, can I proceed by highlighting brief facts in this matter?
Yes. Yes, please.
Separately said and discussed there. If you feel it's still necessary, you can. Otherwise, you can save the time for presentation more.
Indeed, Your Lordship, I just want to.
Yes, yes, please.
I just want to highlight few
Yes, yes,
timelines
yes.
here.
Point number one.
Your Lordship, firstly, according to the fact sheet, it is given that in January 2024, the legal father suffered a severe cardiac arrest. That is, it was like through a hereditary condition that he suffered a cardiac arrest. This can be referred from part 6 of the Moot
Yes.
proposition. And in 12 January 2026, after the petitioner here, R.F. Reddy, attaining her majority, she approached Arogya Fertility Center seeking disclosure. Here, it must be noted that she did not have any symptoms when she approached the Arogya Fertility Center. Later, again in 12th March 2026, she started experiencing cardiac symptoms and palpitation. But it also must be noted that the chances of her inheriting the same disease, like TCV, has been reduced because the biological father did not have this condition. It was just the legal parent, that is Dr. Arvind Reddy, who had this condition. However, it should also be noted that when she realized that she might have this condition and she wanted such information that might help her cure her problem, that is a medical condition here, she did not come back to Arogya Fertility Center. She directly came to the Honorable Court of Swatantra Pradesh filing a writ petition, entirely questioning the maintainability. When there are other alternatives that are available, she did not exhaust those. She directly came to this Honorable Court to file a writ petition. which
So
questions the maintenance.
you mean to say that she did not resort to any other remedy, including asking you personally?
Your Lordship, yes. She did not come back to us, or there are other remedies
She
that
should
are.
have approached the respondents prior to approaching the court, is what you say.
Your Lordship,
What makes the difference?
Your Lordship.
Now you can give this case would be closed.
Your Lordship, I would like to just clarify on this matter that when there are multiple alternatives exist also.
What are they? What are they?
Yes, Your Lordship. Your Lordship, first it would be her testing, like the genetic testing of herself in first matter. And also, Your Lordship, I would be dealing with my issue, this in my issue, so should I proceed it with now only or?
Yes.
I'll proceed with my issues and.
Alternative to 226 is the legal remedy, not the factual remedy. You are now trying to supplement the factual investigations, but they're not. Now, if you want to dispute the jurisdictional point, if you want to dispute the proceedings on the point of jurisdiction, what are the alternative remedies under other laws available may be relevant, not other factual investigations.
Your Lordship, I would like to, like there are multiple boards that have been established by the Assisted Reproductive Technology Regulation Act 2021, read along with Surrogacy Act. In these acts, they have established boards, like the first mechanism that if there's any violation or if you want to seek any undisclosed information, if it's because of medical necessity, the petitioner should have first approached, like this is the statutory basis itself. These acts provide clearly that if there is any discrepancy or any violation of your right, and if it's out of medical necessity that you want to know.
All those acts are recent. By the time of that surrogacy issue generated, these acts were not there.
Indeed, Your
Whether they
Lordship.
are retrospectively can be applied. They can
Your Lordship, we are not saying that it can be retrospectively applied, but when this writ petition was filed, these acts were enforced, and also when all the circumstances have been going on, this laws were enforced. And we were also, the boards that have been established by the Surrogacy Regulation Act 2021, the long title of the act, which is acts as an internal aid here, says that this act is can I take a minute?
Yes, yes, yes.
So,
Don't
like
worry, don't worry.
This Surrogacy Regulation Act 2021 constitutes national boards and state boards, which would help like donor conceived child in case of necessity. They could attain any information or any help regarding their donor.
What is that particular provision? That particular provision which makes the disclosure aspect, or it makes only accommodating or regulating the process of sperm donation and the permitting and necessity aspect as to whether the surrogacy is necessary. That alone appears to be the scope of this act. The subsequent remedies in respect of what has happened are not directly dealt under the act. Maybe section 8 alone, which gives the rights for the child.
Indeed, Your Lordship.
Accepting that, and the offences part is there under separate chapter.
Indeed,
But
Your
this, the remedial part as to disclosure, etc., are not contemplated under the act as such, it appears. Are you inviting attention to any particular provision?
In Your Lordship, we're reading with section 12 and 13 of that is remedy, the first remedy, like you're asking for alternatives, and that's what we are the council is trying to highlight.
Section 12 and 13 of?
The Assisted Reproductive Technology Regulation Act.
ART.
Your Lordship, yes, indeed, Your Lordship.
ART.
It talks about,
ART దీంట్లో దీంట్లో ఉంది. ART
Yes, yes, please.
it is there, it appears. ART is there.
It is there. Yes, please.
section 12 talks about appointment of appropriate authority, where they would investigate complaints, and this would be the first alternative remedy that the petitioner could have gone. Your Lordship, can I proceed with the issues or?
Section?
Section 12 talks about
Section
appointment.
12 insurance coverage guarantee for octi donor.
12 and 13,
You
Your
are
Lordship.
speaking about some alternative agency. Which provision of law, allows this alternative agency or speaks about the alternative agency according to you?
Your Lordship, I could.
Which
hear.
provision of law speaks about the alternative agency? You are saying that some agencies are now provided under the Act, either Act or Surrogacy Act. What are the agencies and which provision of law enables those agencies to go ahead with that this type of tests?
Your Lordship, as cited again, the very purpose of Surrogacy Regulation Act 2021 is where they would constitute national boards and state boards for the same purpose. Again, reiterating the same thing, again in section 12 of ART talks about appointment of these boards by the appropriate government. And
ART rules, are you sure? ART Act, section 12? Yes, yes.
The scope of the act is to regulate the process of donation and incubation and reproduction total till the birth of the child. It appears to be the scope of the act, either act or ART, whatever, both are. Now the issue before us is the disclosure of the
genetic input.
genetic source. And now whether such issue, the protection in respect of such a disclosure is whether contemplated is one thing. Second, whether mechanism for detecting and disclosing that is contemplated. In the absence of the act being silent as to that disclosure, now how do you say, how can you say that this remedy is not available to the petitioner?
Indeed,
Am I clear?
Indeed, Your Lordship.
Okay, please address that point.
The council is allowed to proceed with the issues, and I'll be addressing it subsequently.
Proceed in order. Proceed in order.
As per your convenience, you can.
Much obliged, Your Lordship.
Yes, yes.
Your Lordship, there are three main issues in this matter, and I, as a co-counsel, I would be addressing issue 1 and 2 subsequently, and my co-counsel will be dealing with issue 2 in total and also issue 3.
Yes.
Your Lordship, the first issue here is whether the right to know one's genetic origins forms part of right to life and personal liberty under Article 21 of the Constitution. Your Lordship, I would like to deal this issue in twofold. Whether that is first, whether the right to know one's genetic origins is an essential facet of identity, dignity, and personhood. It is respectfully submitted that the alleged right to know one's genetic origin do not form an intrinsic or an enforceable component of identity, dignity, or personhood under Article 21, particularly where such disclosure conflicts with competing rights of privacy, contractual obligations, and third-party interests. Your Lordship, while Article 21 has evolved through dignity jurisprudence, that is to protect individual autonomy and personhood, such protection is not unilateral. It extends equally to both the sides, including the donor in this current case, whose dignity, privacy, and decisional autonomy are directly affected. Your Lordship, the petitioner was born and raised in a stable and legally recognized family structure. She has throughout her life enjoyed her social acceptance, emotional security, as well as legal recognition as a child of her legal parents. Her upbringing, education, and also development were not impaired in any manner by absence of such knowledge. Your Lordship, identity in constitutional sense is not constituted solely on the basis of biological lineage. It is shaped through living experiences, family relationships, and also social recognition. The petitioner has at all times possessed a complete and functional identity within these parameters. Your Lordship, the Constitution cannot be interpreted in a manner that reinforces one's claimed rights by extinguishing another human's fundamental right. Such an approach would violate the very principle of constitutional balance. And additionally, the confident...
To have the clarity of what points you have addressed, you are addressing, and what was the bifurcation between you, speaker 1, speaker 2, can you give your memorials?
Yeah, Your Lordship, it is submitted.
Memorials of the respondent side?
It's a memo on the red book on the
Okay.
The other one is their memorial.
Respondent memorials. Okay, please, copy.
Yes.
Your Lordship, I'm dealing with issue 1 point now, the first.
Please, carry on.
Confidentiality will be dealt later by my co-counsel, but I would be giving a summary of it. That is, confidentiality in such assisted reproductive arrangements is not merely contractual, but also structural. It forms the backbone of the system, ensuring participation, trust, and also legal certainty.
Yes.
Can I proceed?
Please.
Much obliged, Your Lordship. If such confidentiality is diluted in the first place, it would have far-reaching consequences. First, it would discourage donors. It also destabilizes reproductive frameworks, and it also creates uncertainty in it's already a very sensitive matter, and it would create further uncertainty in such areas. Thus, applying a modern constitutional interpretation grounded in a living constitution, the donor's privacy here deserves to be highlighted as to be protected. Your Lordship, I would like to quote the case of R. Rajgopal versus State of Tamil Nadu, which can be referred in page 21 of the compendium. May I proceed, Your Lordship? Your Lordship, the Honorable Supreme Court in this case held that individuals have the right to safeguard the privacy of their personal life, including matters relating to their family and personal choices. The court categorically stated that personal information cannot be disclosed without consent. Applying that in the current case, that is the donor's participation in this assisted reproduction and his identity are the matters of his personal life. And disclosure without consent or compelled disclosure would directly violate his right to privacy. Your Lordship, I would also like to quote the case of People's Union for Civil Liberties versus Union of India. It can be inferred from page 65 of the compendium. It has been labeled, Your Lordship.
For what proposition? For the proposition?
It's in proposition. Can I just take a moment, Your Lordship? I'll be silent.
Rajgopal case, just give the proportion again.
For the proposition. For what proposition?
Just now you stated,
Yeah,
Rajgopal was, just now you stated the proposition, I'll just confine it again. Sorry.
Sure.
Lordship is asking the proposition in Rajgopal.
In the proposition, it's in page 16, Your Lordship.
Just
For
repeat it
what
again.
proposition you are
Right,
relating
I'm
relativity of the proposition to the factual context in the present
Repeat it
matter
again.
before us.
Lordship is asking to repeat it again.
Your Lordship, indeed, Your Lordship.
Principle, what is the principle? Be helpful to you to oppose the repetition.
Your Lordship, the Honorable Supreme Court in this case held that every individual have the right to safeguard their privacy through their personal life or including matters relating to their family and their personal choices. Here, applying that in this current case, the donors participating in such assisted reproduction and his identity are the matters of his personal life, Your Lordship. Thus, they must be protected under Article 21.
Is it a matter of personal liberty of the respondent, particularly the organization, the center, so-called fertility center, which has, is it a matter of privacy or is it a matter of privacy?
Indeed, Your Lordship.
The privacy issue is with respect to the petitioner or with respect to Bhagavatar or with respect to Arvind Reddy or with respect to the medical center.
With
which
respect to
entertained
the donor, Your Lordship.
only the donor, to the extent of donor.
Indeed, Your Lordship.
Now, whether it is subservient to the protection of life and personal life, Article 21, it falls under 21 or does not fall under 21?
Right to privacy falls under Article 21, Your Lordship.
Okay, now protection of life falls under 21. Now here life itself is in dispute, not mere protection.
Indeed, Your Lordship.
The petitioner is afraid of her life itself.
Indeed, Your Lordship.
Now, because unless she know the genetic basis, etc., the medical issue cannot be addressed. Therefore, the life itself is in risk.
Indeed, Your Lordship.
Then, how can you say issue number one? Your issue number one itself is whether it falls under 21 protection of life or not. Now, life itself is in risk. Therefore, 21 is applicable. How can you say that it's not applicable? What is the justification for you to escape from 21 issue?
Indeed, Your Lordship. We as counsels for respondents, we are trying to establish through the doctrine of proportionality as mentioned in the K.S. Puttaswamy judgment. My co-counsel will, when she's dealing with her issue too substantially, she would be dealing. Yeah, indeed, Your Lordship. Indeed, Your Lordship. Can I cite the doctrine of proportionality or?
Yes, yes.
I'll continue with doctrine of proportionality for the convenience. Your Lordship, I would be citing the case of K.S. Puttaswamy as because the doctrine of proportionality has been questioned. To establish that must be a balance between both the rights. In this case of K.S. Puttaswamy versus Union of India, it can also be referred from page 1 of the compendium. Your Lordship, the Honorable Supreme Court recognized privacy as a fundamental right under Article 21. It is a very well-established principle under this case. It also encompasses informational of self-determination and the right to control dissemination of personal data. The court has emphasized that privacy includes the right of an individual to maintain control over their personal information, particularly where such information is intimate and sensitive. In the present case, Your Lordship, the genetic identity constitutes as one of the most intimate forms of personal data. Compelling disclosure would violate the donor's informational autonomy altogether. The petitioner cannot, like when the petitioner invoking Article 21, that is right to life and health in their matter, to claim access of such information, it must also be looked upon from a perspective where the balancing right, that is through the dignity jurisprudence that has been evolved continuously in the Constitution, it must not be looked through unilaterally, it must also be looked from the perspective of right to privacy of.
Muthuswamy is a double-edged sword. It applies in favor of both, against both.
Indeed, Your
What
Lordship.
both of you are relying on Muthuswamy.
Indeed, Your
And
Lordship.
right to privacy, I know privacy, I have right to privacy to know the parentage, and I have right to dignity to know the parentage, they say.
Indeed,
You
Your
also rely on Muthuswamy for the same proposition that I have privacy and I have right to dignity, and which edge is going to be cut, which edge is going to be protected is the thing you need to put the court in more clarity.
Indeed, Your Lordship.
Where the proportionality, how to explain?
The doctrine of proportion. My co-counsel will be dealing with issue 2 subsequently, so she would be dealing with doctrine of proportionality in detail, Your Lordship. The council seeks permission to proceed with a second fold on the issue 1, that is whether access to genetic origin and medical history is indispensable for the effective realization of right to health, bodily integrity and reproductive autonomy. It is respectfully submitted that the access to the donor's identity or genetic origin is neither indispensable nor constitutionally required for the realization of petitioner's right to health, bodily integrity or reproductive autonomy under Article 21, Your Lordship. Well, Article 21 again has evolved through dignity jurisprudence, which is to include right to health and autonomy. These rights do not extend to claim over another individual's personal and genetic information where there is absence of strict necessity. The councils for respondents are proving on the point of that this medical information, genetic information is not necessity, not at most a necessity at this point of time. Your Lordship, the petitioner seeks to justify that disclosure on the ground of medical necessity, contending that access to such genetic information is required for diagnosis and preventive care. However, the factual record does not establish that such disclosure is indispensable or unavoidable. The medical opinion relied upon by the petitioner in this case merely suggests that genetic history may assist in diagnosis and also in long-term planning. But it does not establish that treatment is impossible or that there exists an immediate and life-threatening situation requiring the disclosure of donor's identity or genetic information in this case, Your Lordship. The respondent also submits that the petitioner's medical claims can be addressed adequately through first having a genetic testing of the petitioner herself and establish clinical protocols for her hereditary conditions, and also that there is an immediate necessity for her to get this information that would help her recover better and take preventive measures. Your Lordship, the present claim here is not therefore of survival, but one for preference for a more convenient and a comprehensive form of information. Your Lordship, even assuming that the petitioner's objective was to safeguard her health is legitimate, that is, it means that, namely that she wants to get the identity of the donor, that is the genetic information, it fails the requirements here, that is, first, the necessity is not established in the current matter, and it also, there are, the measure is not very less.
How do you say it has been established? Because it's part 9 again.
March 26, 2026,
Part
there
nine.
was a medical examination and the opinion is there that
Please come to-
disclosure is necessary
Yes,
for
that is-
the,
Part nine is saying that
even
it's something
procreation and
different.
other purposes also.
Indeed, Your Lordship. Part 9, if I can read it out to you, it says on 12th March 2026, Arif experienced cardiac symptoms, physical discomfort and shortness of breath and palpitation. Your Honor, Your Lordship, I apologize. It must be noted that in this case, as I was reiterating the facts, the councils for respondents, we are trying to say that, firstly, the chance of her inheriting the same disease it has been very limited, even though because this is a hereditary disease that has been inherited, and it's the legal father who has this disease and not the biological father. Even so, if she has doubt that she might inherit such disease, there is no proper evidence that has been given by the medical expert in this matter to say that it is immediate and it is very necessary. I would also like to draw the attention of your lordships to Article 20, Section 21E of the.
Anjali disclosed the entire truth. Anjali, the mother discloses what has happened as to the thing. Then that blood group difference and the disclosure by the natural mother, biological mother, has a sufficient foundation for seeking the information as to whether it is true or not. Who has donated, and the information is necessary in that context. The foundation is there, and how can we ignore that foundational fact, making it necessary?
Yes, please. Yes, yes. Yes, please.
I would answering your question in short, Your Lordship. Part 4 of the Moot proposition says clearly that that no family or history of cardiac disease was there to the donor. It is already mentioned that there is no cardiac history, and that substantiates that the necessity and her inheriting such disease has been reduced. Now proceeding with my, I would just summarize my issue 1 here.
21. Yes, you are saying from 21
Yes.
about hierarchy.
I would, can I proceed with Section 21E?
Yes.
Drawing your attention to Section 21E of ART Act 2021.
21. Yeah, 21. Yeah. Yes, 51.
It has a very strict binding upon any fertility centers or any banks of this nature to have a very strict confidential like whatever the agreements have been there, it must be maintained in a very confidential manner, unless there is a medical necessity that is proved. But here, in this case, the first primary test of her proving, the petitioner proving necessity has failed, Your Lordship. I would like to summarize my, can I summarize my issue 1, Your Lordship? Your Lordship, it is respectfully submitted that access to donor's identity or genetic information is not indispensable for the realization of petitioner rights, as there are alternative remedies available. Effective medical alternative exists and that do not require disclosure at all. And also compelled disclosure would violate the donor's privacy, dignity and autonomy, Your Lordship. Can the council proceed with issue 2?
What is the effective alternative according to you? That's only board only. That's only board. According to alternative remedy is concerned, that's board only. That board one has to approach the board first. Yes. Yes, please. Second issue.
May I proceed with my
Yes.
issues? Thank you, Your Lordship. The issue 2 here is whether the donor's right to privacy may override a donor-conceived adult's medically necessary claim to genetic information. It is respectfully submitted that the donor's right to privacy under Article 21 must prevail over the petitioner's claim for disclosure of genetic identity, as the relief sought amounts to compelled disclosure of intentionally personal as well as sensitive information without consent. I would be dealing with this issue in 2-4 again, and it would be summarized by my co-counsel, as she would be dealing with doctrine of proportionality. Your Lordship, here that the first sub-4 here is that the donor's right to privacy under Article 21 includes decisional autonomy, reproductive choice, and control over disclosure of identity. It is respectfully submitted that the donor's right to privacy under Article 21 extends to decisional autonomy, reproductive choice, and control over his disclosure of his identity. Your Lordship, privacy also again under article was developed through dignity jurisprudence, as I was reiterating earlier. It protects the most intimate aspect of human existence, including decisions related to procreation, identity and control over his personal information. Your Lordship, the donor's participation in the present case was not merely a medical act, but also deeply a personal decision concerning reproduction and genetic contribution. Such participation was undertaken on the basis of a clear and legitimate expectation that his data would remain anonymous. This assurance of confidentiality formed the very foundation of the donor's consent in this current case. Your Lordship, it is now to compel the disclosure of donor's identity and genetic information would fundamentally alter the nature of the consent altogether. It would convert a voluntary act and autonomous decision into one that is retrospectively overridden in the intervention here. Further, the genetic information is not an ordinary data. It reveals lineage, biological relationship, and also predispositions of diseases. It is inherently identifying in nature, Your Lordship. In the contemporary era, even with anonymized genetic data, which carries a serious risk of re-identification, and also due to advancements in technology, it would be very easy for people to trace them back and reveal the identity. Your Lordship, I would also be citing, I would like to take your attention to section 121 of BSA, that is Bharatiya Saksha Adhiniyam, which talks about estoppel, doctrine of estoppel. Here, the entire donation was made on the basis of a clear assurance that while participating in the process, the donor relied on that assurance that was given by the clinic that the entire agreement would remain confidential and anonymous. Under the doctrine of estoppel, once such representation is made and acted upon, it cannot later be withdrawn to the prejudice of the person.
Whether there can be estoppel against a statute, whether there can be estoppel against the constitutional provision and the jurisdiction of the courts. Estoppel operates in what circumstances you want to rely on estoppel. Principle of estoppel, whether it is statutory estoppel or estoppel by conduct or estoppel by deed, what is the estoppel?
Can I just take a moment?
Please.
You understood what Lakshmaiah is saying? There can be an established statute. That's what is Lakshmaiah saying.
When the statute provides for certain disclosure and a right to have a disclosure, can there be a estoppel against a statute and the right under law?
Estoppel of contact is what we are trying to imply in this.
Estoppel by conduct is fine. Estoppel by conduct will not override the statutory provision. There cannot be estoppel against law. Now, when the law provides disclosure, remedy of disclosure, particularly the constitutional law, the constitutional remedy of disclosure in terms of the protection of life and personal liberty and protection Article 21 could be extended, whether estoppel will operate as a bar for 21.
Can we answer this during the debate?
Please.
Much obliged, Your Lordship.
Yes.
Can the council proceed with her issue 2 now?
Yes.
Your Lordship, I would just be citing one case and then moving forward with my second submission here. I would like to quote the case of Suchitra Srivatsa versus Chandigarh administration. It can be referred from page 69 of the compendium. 69, Your Lordship. Yes. Your Lordship, the Hon'ble Supreme Court recognized reproductive autonomy as a core component of personal liberty under Article 21 in this case, Your Lordship. The court held that decisions relating to procreation must remain within the control of the individual. Applying that to the current case, Your Lordship, the donor exercised his reproductive autonomy by participating in such assisted reproduction system under a guarantee of anonymity. Compelling such disclosure would negate the voluntariness altogether and also interfere with his autonomy, that is to control over his personal information. To summarize this fold of issue, the council is submitting that the donor's right to privacy includes decisional autonomy, reproductive choice, and also control over personal information. And any compelled disclosure would violate the donor's dignity, autonomy, and constitutional rights under Article 21, Your Lordship.
Yes.
Your Lordship, the second subsidiary issue that under issue 2 is that the compulsory disclosure of donor's identity falls in the test of necessity and proportionality where less intrusive alternatives exist. It is respectfully submitted that the compulsory disclosure of donor identity fails the constitutional test of proportionality and necessity in this matter, particularly when there are less intrusive and equally effective alternatives are available, Your Lordship. Your Lordship, the present case is not of survival but of medical uncertainty and precaution. While such concerns may be relevant, they do not meet the strict threshold that are required to justify intrusion into a fundamental right, Your Lordship. Further, the respondents also submit that, as repeating again, that there are alternative methods available, including first would be genetic testing of the petitioner herself to understand if she carries such inherent disease, that is TCV in this matter, which she
The petitioner undergo the genetic test. How do petitioner would know about the other person's genetic relation?
Indeed, Your Lordship, the counsel for respondent is trying to establish that first, if she knows her genetic origin first, like she would understand, like the immediate necessity that the petitioners have arrived to the court is because she wants genetic information to know she has the hereditary condition. That can be attained through testing, like getting the genetic test done to herself to understand if she has such condition. And here we are trying to prove that there was no necessity. First, if she wanted to know if she had the hereditary disease, that is TCV in this case, first it would have been better if she would have gone through the genetic testing herself if it is carried by her, which was not done here in this matter. She's directly approached, she did not do that. She directly came to this honorable court to seeking genetic information of a party who also has equal rights of privacy under Article 21, Your Lordship. Your Lordship, the petitioner's own willingness to accept such anonymized and limited disclosure further demonstrates that the direct access to donor's identity is not indispensable in this matter. This undermines the claim of necessity and reveals that the relief sought is excessive in this matter, Your Lordship. Your Lordship, if you're satisfied with this issue, my co-counsel will be proceeding with
Yes.
much obliged, Your Lordship. It was an honor arguing with your client.
Please.
The council seeks permission to collectively address the benches, Your Lordship. Much obliged, Your Lordship. May it please this Honorable High Court, I, appearing on behalf of the respondents, will be addressing issues 2.3 and issue 3, Your Lordship. Your Lordship, at the outset, Your Lordship, we are submitting that the petitioner seeks to elevate a non-existent absolute right over and above the constitutionally protected privacy, contractual sanctity, and the statutory intent of the legislation, Your Lordship. Your Lordship, the respondents respectfully oppose any disclosure of the donor's identity, Your Lordship. I would substantiate this through my issues, Your Lordship. Your Lordship, the first issue 2.3, it states that the forced disclosure would cause disproportionate and irreversible harm, undermining confidentiality in assisted reproduction and violating legal certainty, Your Lordship. Your Lordship, it is respectfully submitted that any compelled disclosure of donor information, Your Lordship, it results in an irreversible and disproportionate harm to the donor, while the petitioner has also failed to establish the proper necessity in this case, Your Lordship. Your Lordship, the donor participated in such assisted reproductive system under the guarantee of anonymity, Your Lordship, which forms the foundation of such assisted reproductive system.
When was the act promulgated? The act was promulgated in?
In 2021, Your Lordship.
The birth of the petitioner?
2008, Your Lordship.
Then how do you apply the provisions that it is prospective or retrospective?
Your Lordship, not only this ART Act, Your Lordship, I am speaking that any such legal frameworks are based on confidentiality, Your Lordship. And during that time, there was the ICMR guidelines, Your Lordship, that is the Indian Medical Research Center for Research guidelines of 2005, which also were in favor of non-disclosure of and anonymity of the donor, Your Lordship.
ICMR guidelines only for adoption or for this also?
For this also, Your Lordship. For surrogacy also, for not surrogacy exactly, for any assisted reproduction, Your Lordship, they are in favor of non-disclosure of the donor, Your Lordship.
At what cost and for what purpose?
Your
Disclosure, the necessity, you started your argument with the opening submission was that unestablished necessity and urgency is the language you.
Yes.
Now, 12th March 2026, RF experienced cardiac problem, and it was the genesis for asking this relief is the cardiac problem, part 9 opening sentence. So, is it not sufficient to take that there is necessity? Unestablished necessity or established necessity? Will you agree that this is sufficient?
Your Lordship, we agree that there is a medical issue to RF, Your Lordship. We are not denying her right to life, Your Lordship. We are recognizing that she has a right to life.
Will you concede that if there is a medical necessity, it can be disclosed?
Yes, Your Lordship. Your Lordship, what we are trying...
You are disputing the fact or you are disputing the law? Factual side, there is no necessity is one aspect. If the factual establishment is there, if the facts are established, then there is acute necessity for disclosure. We have no quarrel. It can be disclosed.
Yes, Your Lordship. Your Lordship, the respondents here are contending that the petitioners have failed to establish necessity, Your
Fine.
Lordship.
Then you are disputing the fact.
Yes.
Now you are disputing the fact as to the necessity, medical necessity and medical urgency. You are disputing that fact.
Yes, Your Lordship.
Now you see the fact pattern part 9. She approached on 12th March and the doctor cardiologist opined with reference to her medical situation, condition. Then where is the basis to dispute? Where is the basis to dispute that that is not sufficient?
Yes, Your Lordship. Your Lordship, in the part 4 of the proposition, Your Lordship, they have received certain limited information about the donor regarding his age 32, blood group B+, and here it is mentioned that there was no family history of cardiac disease, Your Lordship. Your Lordship,
That's why there was no family history. As far as Anjali and Arvind Reddy is concerned, there was no family history. As far as part 4 is concerned, there is a corroboration between part 4 and part 9. Part 4 disclosure is with reference to at part 4 stage, the detection is not based on any family history of that cardiac problem. When it comes to March 2026, without there being any family history, there is cardiac problem which necessitated to know the genetic history of the cardiac problem.
yes.
Part 4. Part 4. You know, the female children. When we do part 7.
So that part is fine. Yes,
Okay, fine.
so you are saying that because in the part 4 doesn't indicate, yes.
Yes, Your Lordship. Your Lordship, that information, while it is available, seeking for the compelling of disclosure of further information of the donor is violating his right to privacy, Your Lordship, and also the confidentiality on basis of which such surrogacy or assisted reproduction are based on, Your Lordship. Your Lordship, I would like
One
to...
more here even there is no family history, and as far as his condition will not percolate to his progeny. If it is to be taken that this Arya is the daughter born because of the donation of this Bhagavatar, which has no family history, but his condition may contribute for Arya. He has no, does not mean his family history may not have, but he may have. That may go to the next generation.
Your Lordship, here if we are
And
establishing...
factual set, since you have driven to the factual set, with the available facts, can't you take that the necessity is also established with reference to his?
Yes, Your Lordship. Your Lordship, as my co-counsel has repeated, Your Lordship, there were alternative options that were available for the petitioner, Your Lordship. Your Lordship, in this case, the petitioner did not seek any alternative remedies, Your Lordship, and Your Lordship has not sought any other alternatives, Your Lordship. She has directly come to the High Court filing a writ petition, Your Lordship.
The same question your co-counsel has said, same question put by the bench. What are the alternatives available? What are the alternatives under law available? Without exhausting that 226 is not available is your argument. What are that alternatives available?
Your Lordship, first,
Not on factual side, on legal side. Now 226 bar on legal side. What are the legal remedies other than 226 available without exhausting that?
Your Lordship, as my co-counsel has mentioned, the sections 12 and 13 of the ART Act, Your Lordship, they mention that any complaints regarding such procedures, Your Lordship, should be taken to an appropriate authority which will further investigate.
There are complaints in respect to the procedures adopted in the process or with respect of the disclosure or non-disclosure.
Your Lordship, disclosure and also comes under the procedure, Your Lordship. Your Lordship, the petitioners are claiming that they form an exception under ART Act, Your Lordship. The ART section 21 clause E states that the clinic should protect the identity of the donor, Your Lordship. However, there are certain exceptions, Your Lordship. Your Lordship, if the petitioner claims that this case falls under the specific exceptions, Your
What are
Lordship.
the exceptions?
Your Lordship, the exceptions are that medical emergency, if there's a medical emergency, or the order of the court, Your Lordship.
Is it a medical emergency now? Which a petitioner is claiming under the medical emergency only always.
Your Lordship, we are saying she should have gone to the appropriate authority with the complaint, Your Lordship. And Your Lordship, further we are claiming that when she approached the fertility clinic, Your Lordship, that was in February, Your Lordship. Then she approached out of curiosity, Your Lordship. But however, she faced the symptoms in March, Your Lordship. And after she has faced the symptoms, she has not come back to the clinic. She has not approached the clinic for disclosure, Your Lordship. Your Lordship, her reason for approaching the clinic at the first place was curiosity, Your Lordship. But we did not fall under medical necessity, and therefore the clinic had refused to provide the disclosure, Your Lordship. Your Lordship, she failed to come back to the clinic after her symptoms were shown, Your Lordship, after the medical necessity as claimed by the petitioners was established, Your Lordship. Then she did not come back to the Arogya facility clinic. Even right now, Your Lordship, the respondents are submitting that if at all the medical necessity has been established with scientific backing and medical backing, Your Lordship, the respondents are willing to concede for a very limited medical disclosure of the medical history of the respondent, Your Lordship.
Even under the act, the clinic shall not supposed to, clinic also they are not supposed to disclose this identity.
Yes, Your Lordship.
Then what is the remedy open to the petitioner then?
No,
Under the Province of Act or surrogacy, whether the clinics or the banks, they are bound to disclose the identity.
No, Your Lordship.
Then
Your Lordship, if they are not, the petitioners claim that the case falls under the exception, Your Lordship. If they would have established such exception, then such information can be revealed, Your Lordship. Further, Your Lordship, here the petitioners are claiming for the identity of the donor, Your Lordship. It has nothing to do with the medical necessity, Your Lordship. Your Lordship, in such cases, in cases of assisted reproduction or surrogacy, Your Lordship, the whole framework is based on the understanding that once a person donates their reproductive organ, they will remain anonymous, Your Lordship. Your Lordship, if the court retrospectively compels the disclosure of such information, Your Lordship, it sends a message to all the it erodes such trust in the trust of the donors in such system, Your Lordship. And further, it will send a message to the future donors saying that the anonymity is not permanent, is not absolute, but conditional, Your Lordship, which would lead to the diminishment of such donations, Your Lordship, the consequences of which will be faced by parents who are trying to conceive children through these processes, Your Lordship. Your Lordship, what we are here standing here the respondents are trying to establish is that any compelled disclosure of any information, Your Lordship, be it genetic or the identity, Your Lordship, without the proper establishment of necessity, it would not only harm the donor in this particular case, but the harm would be inherent and very far-reaching, Your Lordship, affecting the trust of any future donors also, Your Lordship. May I proceed, Your Lordship? Your Lordship, further, even foreign courts have upheld the anonymity in such cases of assisted reproductive, Your Lordship. In the case of Odivre versus France, in page 9, which can be seen in page 96 of the compendium, in the same case, the child was denied, a child born through such process was denied her right to know her biological parents, Your Lordship, and the anonymity of the parents was protected, Your Lordship. Your Lordship, further in the case, Puttaswamy versus Union of India and Rajgopal versus State of Tamil Nadu, Your Lordship, all these cases support that a person has a right to control the dissemination of their personal information, Your Lordship. Your Lordship, the information, be it genetical origin or medical history or the identity itself of the donor, Your Lordship, these all come under a very sensitive, these all come under sensitive information, Your Lordship. And Your Lordship, you are stating that the respondent should have the right to decide how to disseminate such information, Your Lordship. Your Lordship, any compelled disclosure by the court would violate such rights of the respondent, Your Lordship.
We have just now read by the direction, under the direction of the court order, they can provide that information.
Yes, Your Lordship. Your Lordship, we are stating that in this case, the medical necessity was not established, Your Lordship. Your Lordship, we are reiterating that if the petitioner came to the clinic with scientific backing, medical proof and medical expert testimony establishing necessity, saying that without the parental genetic information, the diagnosis would be impossible, Your Lordship. The clinic and the donor are ready to disseminate limited medical information which will help the petitioner with her diagnosis, Your Lordship. Your Lordship, but in this case, without even approaching the fertility clinic, Your Lordship, the petitioner has directly filed the case before the Hon'ble High Court, Your
You have
Lordship.
refused to disclose. It appears you have refused to disclose when they approach it.
Yes, Your Lordship. Your Lordship, the refusal at that point was because there was no medical necessity during that point, Your Lordship. When she had approached, that was in February, Your Lordship, February 2026, Your Lordship. At that point, she had not faced any symptoms, Your Lordship. She had turned majority and she approached the clinic out of curiosity. But her symptoms were shown in March, Your Lordship, and after that, she had not approached the clinic, Your Lordship. Your Lordship, if she has not, even right now, the petitioners are failing to establish the medical necessity, Your Lordship. They are failing to establish that they have tried all the other alternative remedies, Your Lordship.
According to you, what is the medical necessity? If that is the case, according to you, what is the medical necessity and what is the scale on which you want the medical necessity to be believed by you? Are you disputing the already certification done, already done by one doctor?
Your Lordship, in this,
How come that can't be the basis?
yes, Your Lordship.
Is there any standard scale prescribed that this shall be the medical necessity, this shall be the standard, this shall be the scale on which you satisfy? On that, there is no specific guideline.
Your
In one
Lordship,
way saying that on medical necessity I will give. In another way saying that there is no medical necessity. Is it not contradictory? And the medical necessity in fact has been shown with reference to the material.
Your Lordship, in the case of KS Puttaswamy, where the doctrine of proportionality has been
So
laid
then you
down,
are coming, despite there is medical necessity, now you are coming to switching on with the privacy issue. No, at no cost, whether Puttaswamy say that at any cost it cannot be disclosed,
Yes.
whether Puttaswamy direction is qualified or absolute.
Your Lordship,
The privacy is absolutely protected or it is a qualified protection.
it is a qualified protection, Your Lordship. The rights are restricted under a few, if the threshold of doctrine of proportionality is met, Your Lordship. We are not disputing that fact, Your Lordship. We are not even claiming that the right to health overrides right to privacy, Your Lordship. Your Lordship, in this case, we are saying that even under the case, Puttaswamy's case, one of the test of proportionality was, this is the restriction should be the least restrictive means, Your Lordship. Your Lordship, we are stating that in this case, this is not the least restrictive means, Your Lordship. Your Lordship, we are saying the disclosure that is being sought by the petitioner is the most restrictive and most harmful disclosure, Your Lordship. Your Lordship, the petitioners are claiming that the disclosure of identity of the donor will help with both them, will help with cultural identity. Your Lordship, that cannot be
They are all
considered
given
as
up. They are all given up by them. Now they are only standing on only medical necessity. They have given up dignity. They have given up cultural thing. They have given up poverty issues. All they are not on all those things. They are now only when the summarizing of argument was done. They have narrowed down their claim onto the basis of the medical necessity.
Yes.
On medical necessity, if you are ready to do it or not ready to do it.
Yes, Your Lordship. Your Lordship, even right now, I am the respondents are contending that they have not failed to establish proper medical necessity, Your Lordship, because they have failed to establish that other medical means such as genetical testing or even approaching the clinic or other medical sciences have been exhausted by the petitioners, Your Lordship. Your Lordship, if they come to us with the evidence and the scientific backing that the medical necessity has been established, the respondents are right now ready to disseminate certain limited medical information which would help the petitioner diagnose.
Then the larger harm of future donors not coming forward will not be there. Your presentation has been that it is going to be a precedent. On this precedent, everybody will be afraid, and the duty of the disclosure and privacy will not be there. Protection will not be there. Privacy protection will not be there. Therefore, it is not necessary. Is one way. And another way, if the medical necessity is there, it can be disclosed. Again, both are contradictory to each other.
Yeah,
And how can we reconcile the scale to reconcile? Somewhere there must be some
Yes, sir.
balancing.
Your Lordship, we are stating that in the general disclosure of donor identity, with mere claim of necessity should not be allowed because it will set up dangerous precedent, Your Lordship. Your Lordship, but however, owing to the medical necessity and the right to health of the petitioner, Your Lordship, we are stating, we are also establishing a strict threshold and standard of medical necessity, Your Lordship. Your Lordship, if the petitioner is able to meet, if the petitioner is able to establish such strict and high threshold of medical necessity, that is when the respondents are willing to provide information, Your Lordship. Even that information will not include the identity or origins of the genetic origins or any such identifying information, Your Lordship. Only very limited anonymized medical history up to the certain extent that would help her with the diagnosis, Your Lordship, and nothing more, nothing, only up to that level we are ready, Your Lordship. If Your Lordship is satisfied with our arguments, I would like to move on to the prayer, Your Lordship.
There was some more time, no problem. You can still. No.
Rebuttal.
Yes, 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 yes. Yes.
Much obliged. In the light of facts and circumstances of the present case, the evidence based on record, the statutory provisions involved, and the judicial precedents relied upon, it is most respectfully prayed that this Honorable Court of Swatantra Pradesh may be pleased to dismiss the present writ petition as being devoid of merit and not maintainable in law, hold and declare that there exists no enforceable fundamental right to compel the disclosure of genetic origin or donor identity under Article 21 of the Constitution, uphold the validity and enforceability of confidential obligations governing the surrogacy arrangement, and recognize that such obligations are not contrary to public policy, declare that any compelled disclosure of donor identity or genetic information would be unconstitutional, disproportionate, and a violation of the fundamental rights of the respondents, pass any other orders as this Honorable High Court may deem fit and proper in the interest of justice, equity, and good conscience, and for this act of kindness, the respondent shall, as in duty bound, forever pay. It is an honor arguing before you.
Yes.
Much obliged, Your Lordships. Your Lordships, the respondent councils have time and again relied upon Assisted Reproductive Technology Act, and in the same guidelines, that is guidelines of art clinics in India, which clearly stated 3.36 that to keep all information about donors, recipient, and couples confidential and secure, the information about the donor should be released by the art clinic after appropriate identification only to the offspring and only if asked by him or her after she reaches the age of 18 years or as and when specified and required for legal purposes, and never to the parents, Your Lordships. The council is submitting.
Fine. Now, one interesting new point after their presentation has come to light is that there is no history of cardiac problem highlighted by them. Your disclosure, now you saw it, because of the cardiac problem discovered on 12th March. When there is no family history in respect of the Bhagavata, then what is the purpose of this petition? Then the information you sought, that whether is a genetical history as to cardiac problem, you went there with the cardiac problem. And that cardiac problem information is very much available, that there is no history. And there is a question of further, now the disclosure is whether for the medical purpose as to genetic history of cardiac, or the disclosure is who is your parent. It is, for the purpose of medical history, we can understand. It is for the disclosure of parentage, something is fishy, something it's not necessary. It is correlatable to the medical, okay, reasonable. Not related to the medical, not reasonable. Now, the established thing shows that one way they are disputing that it is not sufficient material to believe that there is acute medical necessity, even if it is presumed that there is medical necessity. Since the medical history of the cardiac problem is not there, no useful purpose will be served by giving any direction, and the direction is only for medical purpose only.
Your Lordship,
Furthermore,
answer.
even if he is now mere disclosure of parentage by this center is sufficient, or the history of that individual Bhagavata is necessary. Treatment and subjecting him to medical test is necessary. Subjecting him to further medical examination is going to be a disclosure of his personal information.
Please come to page part 6 and part 9.
Indeed, Your Lordship.
What is part 6 say?
Part 6 says about that Aravind Reddy suffered from a cardiac history,
What is that? Telanganam.
cardiomyopathy variant.
Now come to part 9.
For definitive diagnosis of suspected TCV requires paternal genetic history.
Now come to this part 4, second part.
Part 4, Your Lordship.
Part 4, second.
Okay.
That, donor's information.
Indeed, Your
That
Lordship.
this is related to that Arvind Reddy suffered some TVC,
Indeed, Your Lordship.
and the petitioner, according to you, she is also suspected with the same TVC.
TCV, yes, indeed, Your Lordship.
Then why you are asking the information of the other donor then?
Because as already provided by the counsel for the petitioner about the blood group.
No, it's an admitted fact. Don't go to find the gap in the fact pattern. Fact pattern cannot have the fact pattern.
Before us the
It is, as rightly said by the bench, on 12th January 2008, the clinic revealed that age 32, no family history of cardiac disease. But he might have possessed the disease variant or something after the 18 years, in the course of 18 years, which might in turn, the variant might have shown up, maybe at not that time, but when he was 40 years or 45 years old or something like that, Your Lordship. It might have not occurred then, but there is a high possibility that it have occurred in the later coming years, that is after 18 years,
only
there is a
suspicion,
chance.
because suspicion you want to approach the court, but not to enforce the legal right. Because you suspected something, you want to enforce your you want to enforce a fundamental right in the guise of the suspicion.
It's not a mere suspicion, Your Lordship. It is the facts which are applying the facts in the present case. It is not suspicion, Your Lordship.
Yes, please. Yes.
And moving on to the ICMR guidelines, they have stated to also the counsel for the petitioner humbly seeks the answer from the honorable respondents that how does ICMR guidelines, when there is no statutory framework during the confidentiality agreement, they relied upon the ICMR guidelines. But when guidelines is in conflict with the act will prevail definitely. So how are they not relying upon the constitution and they are only relying upon the guidelines? Act definitely prevails over. And one more thing is, Your Lordship, that time and again the respondents have stated that they did not, the petitioners did not approach the Arogya Fertility Center. But when this writ petition was invoked, they have clearly stated in page number 5 of the Moot proposition, Your Lordship, the first two lines, that respondent contended that any compelled disclosure of genetic or biological identity would constitute a serious infringement. If they are saying that we will definitely give the information if there is a medical necessity, and we have also established that there is a medical necessity for the diagnosis of PCV. So then why are they contending that? Why are they again refusing that we will not be giving the genetic information, Your Lordship? That is the question before this honorable bench. And to also highlight, Your Lordships, they are saying about the respondents are trying to deviate the factual matrix of this Moot proposition as to identity and all. Our main preliminary relief is that to know one's genetic origins, and alternatively, a disclosure of medical or genetic data via neutral mechanism, Your Lordship, and interim genetic testing without public revelation. We are not asking for the public revelation of the donor 32, which if inferred from the facts of the Moot court proposition, we are not asking for a public revelation, Your Lordships. So we are asking for a very neutral approach. So then why are the respondents time and again they're contending that they are not willing to give the genetic information, and they are also stating that privacy overrides health in the present case, Your Lordship. The counsel for the petitioner also brings to the honorable bench that in Justice case Puttaswamy versus Union of India, as clearly held by the honorable Supreme Court, that privacy is not absolute. But in the present case, health takes precedence, Your Lordships, because there is a lack of vacuum in the genetic information, the limited disclosure which was given by the clinic, Your Lordships. And furthermore, Your Lordships, they are saying that we need to go for we need to approach the medical practitioner or any other alternative genetic testing and such all, Your Lordships. But here the medical practitioner, her cardiologist himself has stated that for TCV's diagnosis they need the paternal genetic history. So then why are they denying even after the writ petition is invoked before this honorable court? They are time and again denying that we are not willing to give the genetic information, Your Lordships. And they have completely relied upon Assisted Reproductive Technology Act, and in the same guidelines itself, it has clearly stated that after the attaining the age of majority, the donor conceived adult can definitely know the information, Your Lordships. So this is the question before this honorable court, which the counsel for the petitioner humbly seeks, Your Lordships. Much obliged, Your Lordships. And Your Lordships, to also continue with, they have time and again stated that the petitioners did not qualify or did not meet the criteria of proportionality test as laid in Justice case Puttaswamy versus Union of India. The counsel for that the counsel for the petitioner would like to answer that legitimate state aim is that in the present case, protection of petitioner health and life, and rational connection is that genetic disclosure enables diagnosis for TCB, and the necessity is that no alternative method to obtain the paternal genetic history, Your Lordships, in the present case. And the balancing interest is also that health and survival outweighs reputational concerns in the present case, Your Lordships. And we are also asking for a very neutral mechanism of approach, Your Lordships. Much obliged.
Again, rebuttal.
There cannot be reply to the reply. Normally, there cannot be reply to the reply unless the court asks. Where is the end? Again, they will ask.
With your permission, Your Lordship.
Even permission is one thing, direction is another thing. We entertain anything, we will ask. Again, if they want, what shall be the modus operandi? Again, then, where is the end? So, what is the important point? Even for permitting, what is the point you wanted to clarify?
Your Lordship, we are intending to clarify.
What is the new point raised in the reply? If at all they have raised any new point in the reply, you are entitled to answer. Firstly, they have submitted argument, you have replied. They are given chance to reply. It is a convention and they shall be given to answer since you write. Now, beyond what has been said in your reply and original presentation, what is the new point, one new point raised by them? Then you are entitled for reply. What is the new point?
Your Lordship, the new point that they have mentioned that the ICMR guidelines are contradicting the ART Act. We would just like to clarify that the ICMR guidelines, Your Lordship, they also oppose disclosure. At the same time, the ART Act also opposes disclosure of the donor identity, and that they are not contradicting, Your Lordship. Your Lordship, the reason we have stated ICMR guidelines because that is the only thing that was existing when the surrogacy happened. ART was a recent act, Your Lordship. So that's why we relied on ICMR instead of ART, Your Lordship.
Just clarification. Just clarification.
Yes, Your Lordship. We would like to rest our case.
Please.
Much obliged.
If the Honorable Bench is satisfied with the proceedings, we respectfully request the court to permit the conclusion of today's session. The court is now in recess. We request the audience to remain seated.
before the much awaited the result that the organizers will do. And as far as the comments of the bench are concerned, our sincere appreciation for the organizers, and from day one of the selection of the moot problem, and circulating it and getting the views and compilation and approaching the judges, and lot of homework and teamwork, certainly evident from the way in which the things happen. So they deserve every appreciation from our end. We appreciate the institution for it's a emerging and a new area. The surrogacy is a area, and the future litigation much is going to be on this. Now, of course, it's a budding, but even at this budding stage of the legislation and the area, the depth in which the institutions are going on and the participants are going on, giving us a lot of hope that the future is going to be more glorious and more interesting. For that, we congratulate and appreciate the participants, all participants in general, and in particular the finalists. And the only thing in lighter side, I can say that I don't want these people to come to my court, because it will be very difficult for me to decide who is better. Equal performance, and of course one have to ultimately have the winner and runner up. But the presentation pattern and everything, if everyone has seen, and we have also seen from my personal friend, with the permission of my brothers, I must add that they deserve every appreciation. Both teams deserve every appreciation, and all the teams every appreciation. So keep it up. And the new area and literature is also not much available. And within the available literature, all hypothetical situation has been well addressed by you. And at your level, if I just imagine myself going back to 30 years back, where I was in the student days, and I would not have done this. This is the only comment I can with this. I also rest leaving the things to happen, because I don't want to stand much before the cup and the lip and the lunch that is much awaited, and the other formalities are also going to happen in the short time. I rest here.
I would differ in fact, I request you people to attend my court, because that's how we have to develop the law. We have to develop the law, because see, this is how if you start arguing like this, you always new points will come, will emerge. And this presentation is in fact some way, of course, is a now emerging law so far in India is concerned, and the research in fact you people did is something very commendable. That's what probably, and in fact probably if you are filing students, I'll wish you the best of luck in your future endeavor, and it's a good thing you did.
before proceeding with the ceremonies, we express the honorable judges for presiding over the session. The session was nerve-wracking for the participants. Obviously, we have been in those seats. We understand the tense situation they are in. But it was at the same time intellectually stimulating for all of us as audience. So while the tabulation team works with the result and preparation of all rounds, there's a felicitation ceremony. So for this, we request our Honorable Pro-Chancellor, Dr. K.S. Jagannath Rao Garu, to felicitate the Honorable Judges with shawls. Volunteers who are with the shawls, please.
Now we have calculated as a board, so it comes to the president. As your convention around there, what is your convention? Doing it here or doing there? We go by your convention. But
Dr. K. Suresh Reddy Garu, he has presided over this competition for the second occasion. We wholeheartedly thank for his presence. Honorable Justice K. Subba Reddy Garu. Justice Subba Reddy Garu, we thank you. Honorable Justice Haranadha Sarma. Now I request our head of the department, Dr. Venkateshwara Podle, to give a souvenir to each of the honorable judges. And before that, we have unveiling of trophies at the same time. So I request Honorable HOD sir to do unveiling of trophies off stage there. May the volunteers help to felicitate honorable judges with the souvenirs one by one.
I request all faculty to come out.
We request everyone to settle down, the volunteers and all. If the tabulation team is ready with the result, we're going to announce the results. Yes. So we have first category awards. We'll start with them and then we move. So I expect both teams to hold their nerves on some moments, some more moments. So let's start with the best researcher. The best researcher prize goes to Kamila from B.S. Abdurrahman Crescent Institute of Science and Technology. We'll call you upon. We're just making announcements right now. We'll call you upon for receiving trophies in a while. Best Memorial, second category. The Best Memorial Prize goes to the team from Dr. Ram Manohar Lohia, National Law University. And as per the terms of the competition, it's the only team which scored above 90% score in all 4 rounds of evaluations consistently. So I apologize if I mispronounce the names because we are not familiar earlier. So it's Sampurna Rastogi, Ishani, and yeah, Ishani is acting the both roles. Is the team here? Okay. Now we have 2 oralist categories. One is male oralist and best female oralist. The best male oralist prize goes to Arya S. from Savita School of Law, Chennai. The best female oralist prize goes to Manikala Pavan from Alliance University. Now the most awaited, I don't need to announce the runners up, we just need to announce the winners, and both are announced with a single statement. As per the decision of the Honorable Bench, the winners of this competition, the 5th KL Memorial Inter-University Moot Court competition is Nandini, Gauri Kaushal and Rahila from Siddhartha College of Law. Okay, where's the others? The other category. Now we should start and now calling them one by one. Yeah. Now we would like to call them one by one, and we request honorable our dignitaries to join this on the stage for trophies. So the first is best researcher. Play. Is that ready? So we request the best researcher to come over the dais and receive her trophy and a ceremonial check of 5,555 rupees. Who is carrying the check? We request the winner to stay back for the receiving of the ceremonial check, please. Now we request the team who has won the best memorial prize to come over and receive their trophy and the check. It is Sampurna Rastogi and Ishani from Dr. Ram Manohar Lohia National Law University. Next we call upon Best Male Oralist S. Arya from Sojita School of Law, Chennai. Next, we request Best Female Oralist from Alliance University Central Campus, Manikala Shravika Pavan, to receive her prize. We call upon the runners-up team of this edition from Alliance University, all the three participants, to come over the dais and receive their ceremonial check of 333 and the runners-up trophy. The checks are, we apologize, the checks are not yet ready because the names are being written, so it takes a while and we have to speed up the process. The name writing is ongoing here. We call upon the stage the winners of this edition from Siddhartha College of Law. His name? Rahila or Rohit? Gauri Announce the certificates of all the other participants one by one. If the checks are ready. I request the technical team to go for the display of marks for different rounds. In addition to that, we have the original code is retained, signed with the judges' signatures. So we have Xerox copies available. Any team is interested in knowing their marks from any. You can take the Xerox copies with you. You can click the pictures by contacting the tabulation team in a short while. They're getting the Xerox finals ready. Minutes. No. Go to payment also. If equity sir is available, he will give. नमस्कार बोलिए आए He said he will be there. No. Okay. So on stage or here? It's not picture frame. Video. We request Dr. Kamsai to felicitate the runners up first with the checks. So we call upon the runners-up team to come to the stage and receive their checks. Now we request the winning team to come up on the stage and receive their Simple check of 44,444. Apologize, I don't know a lot of Telugu, but I know it's a lot of Nalugu, Nalabai and Rupai. Whoa. Score sheets and certificates from the tabulation desk with a minimum fuss we request, and if they want to look at the results of the proceedings terminate for the day, we have a facility of lunch. Please join us in the lunch.
Be there or can we leave?
No, it's over now. No, they're having lunch. They'll eat. Then they have to let them eat. They'll leave in 10-15 minutes. They'll leave in 10-15 minutes, I suppose.